From the Library of Congress in Washington, D.C.
All right, hello everyone, welcome back. This is the Section 1201 Rulemaking. So this is the second panel we are holding for Class 1, which concerns the circumvention of audiovisual works for criticism and comment. And this is a category which was combining 7 previous exemptions, which the registrar has tentatively determined she can recommend renewal of, and discussing proposed modifications or expansions. The panel immediately prior to the lunch hour focused specifically on issues affecting ebooks and filmmaking current exemptions. And this one is a little bit focusing first on a more broader category of how this might be expanded, and also specific issues affecting educational uses of short portions of audiovisual. So my name is Reagan Smith. I'm Deputy General Counsel of the Copyright Office. I see a lot of familiar faces. So we on this side will introduce ourselves, go over briefly rule of the road, and then have you introduce yourselves, and then we'll get started.
Emma Kleiner, Ringer Fellow at the Copyright Office.
Kevin Amer, Senior Counsel in the Office of Policy and International Affairs.
Anna Chevet, Assistant General Counsel at the Copyright Office.
Jason Sloan, Attorney Advisor in the General Counsel's Office at the Copyright Office.
Stacy Cheney, Senior Attorney Advisor, National Telecommunications and Information Administration, NTIA.
Okay, so again, thank you all for coming. We're going to try to focus on areas where we can build out or format discussion where there's maybe discrepancies or disagreements in the record. Take your placard up if you would like to speak. We'll have brief introductions, a little bit of questioning, and then go into some multimedia presentations. So, Mr. Band.
I'm Jonathan Band, representing the Library Copyright Alliance.
I'm Peter DeCherney, a professor at the University of Pennsylvania, representing the Joint Educators.
Peter Midgley, representing Brigham Young University.
My name is Renee Hobbs. I'm a professor of communication at the University of Rhode Island, representing the Media Education Lab.
Matt Williams from Mitchell, Silverberg, and Knupp, representing ESA, AAP, MPAA, and RIAA.
Bruce Turnbull, representing AACS-LA.
David Taylor, Counsel to DVD Copy Control Association.
So as we've done with previous panels for this rulemaking is that we are going to focus on different buckets of questions. So everyone's going to have a chance to kind of have their say, but we're going to try to kind of go through these different buckets. We do have 2 presentations that are going to be given at various times, and we have them set up, but I will kind of cue for when that should take place. Okay. So the first bucket of questions, we are going to focus on the elimination of distinctions between users, because you have both BYU's proposed exemption eliminating distinctions between educational users, and then you also have the broader, no one is here from EFF or NMR today, but we also have kind of this broader category of eliminating distinctions. So on that issue, so DVD, CCA, and AACS-LA, they state that expanding having BYU's proposed exemption and expanding the current university exemption to cover nonprofit educational purposes would be too broad. So opponents, is there a way to eliminate the distinctions between educational users without an exemption being too broad? Opponents. You guys said that was too broad, so okay. Is there a way to eliminate distinctions between educational users, perhaps using a different phrase, and if so, how would you do that? Or Mr. Williams, if you'd like to speak with that, to that.
We did try to offer new potential language, but what we tried to do was preserve all of the existing boundaries that have been built into the exemptions, because we think they're all based on the record evidence and that they've been carefully thought out and drawn out, and there's not really anything new in the record that would lead us to conclude they should be changed at all. So we do think it could be redrafted, but that the actual contours should be preserved.
So there's currently sort of a tiered approach to varied educational uses depending upon whether one is at a university or collegiate level, K through 12, or an educational use outside of those. And I wonder, maybe you can speak to why you think it's appropriate to maintain all those divisions, and then if proponents want to discuss whether it might make sense to bring it up to a larger nonprofit educational purposes, perhaps affiliated or not affiliated with an institution, and if so, what evidence in the record, including this current record, would justify altering the current regulatory language?
Sure. So as I was saying, I think the distinctions have been drawn based on the record, and for example, with K through 12, they have the screen capture exemption. I think Ms. Hobbs submitted an opening comment saying, basically, thank you for granting us that. It's helpful and it's working well for us. So I haven't seen any new examples of things that are preventing them from engaging in the kinds of educational activities that they want to engage in. And similarly, when you move up through the university level and then on to MOOCs, the contours that are there were drawn based on what people said they needed to do, what the office concluded about whether those things were lawful or not. And when you get all the way onto the online environment, the office wisely brought in portions of Section 110 because Congress had already spoken to some of the ways that you can help to alleviate potential risks while also allowing for the uses that are legitimate. So I think that's why we would advocate for preserving them the way they are, is that we've basically got the same record that we have last time, and all of the contours were drawn based on the record.
So if I may just respond, this is Peter Midgley from BYU. Our proposal is that we should, instead of drawing these artificial distinctions between different categories of educational users, that we should just recognize them as a group in the same way that the statute does. So 110.1 and 110.2 are very clear. They don't make distinctions between film studies professors or K through 12 educators or anything else. And so we view the best way to proceed to simplify and consolidate this is to just tie the exemption to the conditions that have already been codified and set forth in the statute.
Mr. Band?
So following on that, I mean, it's if you just look at the existing exemptions, I mean, the amount of words that are devoted to these educational exemptions is extremely long. It's very complicated, and certainly, you know, as indicated in the EFF submission, but certainly our experience, and I'm sure Mr. Midgley has the same experience. It's so complicated that it's hard to use, and you basically would need to consult with an attorney before you can do anything with it, and that just is sort of unworkable and unnecessarily unworkable, and it's both in terms of you know, having this tiered approach where certainly from the point of view of educators, you know, education is education, and you might be the same person teaching at different levels depending on, you know, the day of the week. But the basic process is the same, and the needs are the same, and the students' needs. And it doesn't matter whether you're a high school student or a college student. Either way, your needs are the same. And so. But the existing system is just so complicated that a lot of people just kind of throw their hands up in the air and then do one of two things. They either just say, okay, I'm just not going to deal with this, and that harms the education, or they're going to say, I'm not going to worry about this, and just do whatever they're going to do. And neither outcome is a desirable one, right? We don't want people not using the best materials possible to educate students in this country. At the same time, we don't want people to disregard the law. And so the right approach is to figure out how do we make it easier for people to comply with the law. And that's why we're here. We could easily just say we're not going to worry about, the likelihood that, an MPAA member is actually going to sue a high school teacher for what she does in her classroom is pretty small. But again, that's not the point. We want to comply with the law, and at the same time, we think we should be able to make the best use of these materials. And you would think that the rights holders, for their part, would want educators to use these materials as much as possible, because they have created fabulous content, which is part of our national dialogue. And you can't conduct education in almost any area without using this material. Okay, this is the world the students live in, and so that is a tribute to the enormous creative activity of the folks in the motion picture industry in particular. So they should make it easy as possible for us to study it and for us to teach students how to use these materials and understand these materials. And that's, at the end of the day, that's what we're trying to do, is to just make it easier to use these materials and comply with the law, and at the same time, none of this, in our view, in any way harms the interests of the rights holders.
Thank you, Mr. Band. I would like to offer you the opportunity to build off on that or respond to that, Professor Hobbs. And I think part of why I think your perspective will be valuable next is that the existing exemptions are kind of here. They've evolved based on the record. And so can you speak to, Mr. Band just said that the needs are the same from whether you're a student, whether you're participating in media literacy, K through 12 or university, depending on the subject matter, you still have the same needs, versus Mr. Williams has suggested that maybe the needs are different depending upon the activity that is sought to be engaged. So any specific examples you can provide us from your educative experience will be very helpful as we evaluate this.
Thank you. Mr. Band is right in that anything you can do to simplify and streamline the law and to bring it into alignment with Section 110 would be great. It is extremely confusing for teachers. The group of teachers who are most struggling with the law in its current formulation are K-12 teachers who also participate in teacher education programs at colleges and universities. As you know, it's very common for a high school teacher or a middle school teacher to teach also in a university context. So there's a situation where, well, which part of the law should she feel responsible to model, to comply with? This is a particular confusion to them, and I think that has an impact on how the next generation of teachers is taught how to use audiovisual resources effectively for purposes of teaching and learning. So you asked me to talk about, are the needs different between different types of users?
Right. I mean, in the past, we've said maybe a screen capture techniques get better and better, and they're very simple to use. That might be fine if you're just wanting to show something as part of, a science project or something, compared to when you need to look at the image quality and really understand what was going into composition of the image. So things like that is what I was referring to.
Got it. So the one place where I think we're seeing an evidence base arising about differences in use has to do with the narrow formulation of the phrase criticism and comment, right? We're learning from the literature on teaching media literacy to younger users that some pedagogical activities that are building blocks of learning might not actually narrowly fit under that narrow formulation. And so we're in agreement with the BYU a proposal that any educational uses should be important, and that we also are in agreement with we would like to remove the restriction on short portions, as we feel like that also unnecessarily compromises teachers' ability to use pedagogically researched and well-informed practices.
Just a quick follow-up question on the short portions. Because you want to comply with Section 110, but you also have Section 110.2, which, all granted, doesn't use the term short portions, but that is essentially when they're dealing with distance learning, that's really all you're allowed, like a reasonable amount. It's not supposed to be the whole motion picture. So in cases when you're dealing with compliance with 110.2, would it be reasonable, or I should say, when you're dealing with distance education, and if you're trying to comply with 110.2, if you want us to incorporate that into the exemption, presumably keeping the short portions for that type of learning and teaching would be appropriate?
Well, I think, if I may, so our proposal, again, would just be to tie it to the underlying activity. In other words, the purpose of this proceeding is to decide when circumvention is appropriate. And if a user ultimately is going to use more than the reasonable and limited portions that are permitted under 110.2, then that's an act of infringement, and the circumvention that might have preceded that act of infringement would also be would not be eligible for the exemption that we're proposing. In other words, the exemption is tied directly. If the underlying use is not infringing, then the circumvention that got you to that use is not a violation of 1201. And so it's just, there's no need to try to bake into these rules a separate set of requirements. You just say, ultimately, a non-infringing use, which is one of the conditions for granting these rules, that satisfies the conditions of 110.1. And again, 110.1 has no short portions limitations. You can show the entire film in a face-to-face classroom setting. And if circumvention was required to get you to that performance, then that circumvention we submit should not be a violation of 1201. And the reasonable limited portions that you need for 110.2, the same thing. So again, instead of trying to relitigate the policy issues that were underlying the infringement conversations that happened in the 70s around 110.1 and 110.2, we would rather just focus this proceeding on the circumvention that may prevent educators from taking advantage of those exemptions that already exist in the law. They're already codified and they're already there. One other point that I neglected to mention earlier that I feel like I should is, with all due respect to our ebook authors and filmmakers and other folks who were here earlier as well, lumping all the educators together with that group of people may cause some problems. So this may be a situation where it may make sense to have, even though in general, of course, we support the notion of simplification, consolidation, making it easier for people to use, there really is a special statutory preference that's shown for nonprofit educational users, which we don't think has come through adequately in the current rules. And that may be due in part to the fact that the educators have been lumped in with another group of people, and that might not be appropriate either.
So, so would it be reasonable then to hypothetically have two exemptions for this? Like you had to have one for educational purposes, which would encompass the educational uses that are currently covered, and then you might have one, say, for non-commercial purposes, which could include ebooks and filmmaking and non-commercial videos.
Right. So again, educators, of course, are all the time making use of 107, just like our documentary filmmaker counterparts and the ebook authors and other folks who are making fair uses, non-infringing fair uses, and educators certainly make those kinds of uses. But in addition to those, we also have separate statutory exemptions in 110.1 and 110.2, which have been specifically negotiated, hashed out, and we think that 1201 should reflect the same policy that's already sitting there in the statute for 110.1 and 110.2. And so that may, we're just proposing that might be a way to simplify the educational exemption, so that what Mr. Band is talking about, that educators have a very simple exemption, a 1201 exemption, that enables them to do whatever they need to do to get to a non-infringing performance for educational purposes.
So I know, I see a few placards up, I believe it was Joint Creators commented that not all educational uses are necessarily fair use. Perhaps Mr. Mullins, you might want to touch on that, and if you have any suggestions on trying to divide non-infringing versus infringing use in an educational context.
Thank you. Yeah, first I wanted to say that, so Section 110 is about performance and display. So circumvention is not required to take a lawful copy that you purchased into the classroom and engage in a public performance that's covered by Section 110. There's also ways of performing it online that would not necessarily require circumvention. What the circumvention is getting at is the desire to make copies, right? And so the exemptions are already going beyond Section 110 because they're enabling or at least saying that in many instances some level of copying is fair use, not that it's expressly covered by Section 110. So I just wanted to clarify that issue. The implication of the fact that the reproduction right is not covered in 110 and the implication of the fact that 110 has boundaries is that when you exceed those boundaries, there is a question as to whether the conduct is lawful or not. So of course there are things that educators could do that would be unlawful. I would submit that what BYU is proposing, basically just hacking all of their disk and passing around digital copies around the campus, that's not a fair use, and it's a form of space shifting that is not a fair use. So I don't think that in this proceeding we're going to be able to define everything that might be done in an educational context that would qualify as infringing. What I think you have to do is look at the record, see what they've put forward to establish non-infringing uses, and then try to draw the exemptions to address what they've put forward. And I think that's what you've already essentially done. So I don't think there needs to be any change other than as we offered a shortening of the language, which can be done in various ways.
I guess I have sort of two follow-up questions for you on that. I mean, first is what would you say to 107, which explicitly says that multiple copies for classroom use are likely to be a fair use? And then second, I'm wondering how much you've said you're taking issue with whether the uses would be non-infringing, but is it really more, is it separately a concern that whole works would then be in the clear distributed? So it's like going to a 1201 issue of access as opposed to that the actual classroom use itself would be infringing.
I would not say that the concern about in the clear copies is necessarily more the issue, but it is a big part of the issue. Of course, when you're dealing with hacked disks or in the clear digital copies that can be spread around quite quickly, harm can result quite quickly, and there's no way for my clients to monitor the source of that harm. The proponents often say, well, then no one's ever been able to point to someone who claimed to use an exemption and then the copy fell into the wrong hands. There's no way for us to do that. We have no line of sight into who is using the exemptions and who might be misusing them. So that's just something we can't proffer. I'm also quite concerned about the acquisition of copies of works that should be paid for. There's nothing that says that all copying by educational institutions is fair use. And you're correct that there is a reference to multiple classroom use copies. I think that was really referring more to the literary work context and to the need on occasion to essentially create a couple of copies to use in the classroom. That's a big difference between having a university hack into disk or other digital copies, create a bunch of server copies or pass them around campus. It's very distinct from what was being talked about in 1976 when that language was included. So I guess that's how I would address it.
Professor DeCherney?
Thank you, Peter DeCherney. I'm a little hesitant to say this because I'm not sure which side it helps. But as I understand it as a non-lawyer, both 110.1 and 110.2 are safe harbors. They're not coincident with fair use. In many cases, they allow for uses which are not fair use, like showing an entire work, which may or may not be fair use, but we don't know. And then there are also many cases when using work both in an online teaching environment and in a residential teaching environment may be fair use but are not covered by Section 110. 1201, as I understand it, should be about protecting Section 107, about protecting fair use.
It could be about non-infringing uses general.
Okay,
so
but non-infringing, okay.
110
No, it's okay,
yep.
no, it's exactly,
Yep.
exactly. I was skeptical when the EFF wanted to propose a kind of joint amalgamated exemption, and I actually think they did a very nice job of trying to bring together and synthesize the way many of the exemptions work. I don't know if it'll work in every case. Maybe there should be 2 rather than 7, not 1, but definitely some kind of amalgamation would be really helpful. I know it's not just that users need to hire lawyers to understand the exemptions increasingly, but even when you see these exemptions reported in the popular press and even in the kind of technical press, I'm amazed how often they get it wrong. One case that surprised me last time was TechCrunch, usually very good in the policy reporting, said in the MOOC exemption that Coursera courses could not be take advantage of the exemption because they were for-profit. When it's very clear in the way you've drafted it that as long as the offering institution is nonprofit, it's okay if the platform is for-profit.
Thank you. Mr. Midgley, then Mr. Ban.
Yeah, just a couple of points in response to this notion of course, we understand that that 110.1 and 110.2 are about performances, not copies. That's what 112F is for. 112F specifically talks about the copies that are necessary to make 110.2 performances. So, and to the extent that you have...
but that's not what the exemption you're seeking would be, permanent copies.
Well, my point is simply that the circumvention that you would need to get yourself to the non-infringing performance of 110.1 and 110.2, if there's an intermediate copy that's necessary, that's a non-infringing copy either under 112F or under 107. And I would just point to, Google Books and HathiTrust as examples of cases where full copies of millions of works reside right now on servers hosted by a for-profit private company, and the court has ruled in that specific instance that those full copies that exist are fair because they enable the transformative use that researchers need to make downstream. And so in a very similar way, the server copies, the intermediate temporary server copies that would need to exist to make these non-infringing performances under 110.1 and 110.2 would be covered either under 112F or under 107 as fair uses.
So if you're traveling into 107, Google Books said a full copy is fine for search purposes because there doesn't substitute the market for purchasing. Is it your contention that that would stretch over into full copies for educational uses?
I'm simply trying to make the analogy that a full copy of work, millions of full copies of works residing on a server, when the court looked at that issue, the ultimate underlying use was the non-infringing use that you had to make in that instance was keyword searchability of the full text of those works. And an intermediate step that was required was to have a full copy residing on the server that still resides there to this day. And that full server copy is a fair use because the ultimate underlying objective is to make a non-infringing fair use of the full server copy. It's the same example here. We're trying to make a non-infringing use that is a non-infringing performance in a classroom, a face-to-face classroom teaching situation. And again, to do that, you need a full copy if you want to show the full movie. And that necessary intermediate copy that you need in the exact same way that the full copies that sit there on the Google servers is a fair use if it's not covered specifically under the 112F provision for ephemeral recordings.
A few follow-up questions on that, because for Google Books, the court found that the use was transformative because people could search it, so it was not the exact same, it was not like they were just putting the books up and people could look at them in their original form. Like here, you're basically ripping a movie and just showing the exact same movie. What's transformative about that use?
Well, it may be transformative depending on, the specific teaching context in which it's being used, but whether it's transformative or not, it's non-infringing. It's non-infringing under 110.1 or 110.2, or the exemption that we're seeking wouldn't apply. If you're using it in an infringing way, then the exemption doesn't apply.
But you keep saying the use is fair use. So I guess I'm wondering, so are you using fair use as the basis for your position? Or?
Yeah, sorry if that's not being clear. So what we're saying is that that there's an ultimate use. That's the performance, the non-infringing performance that's going to happen either in a classroom or in an online distance education setting under 110.1 or 110.2. And that performance is non-infringing as long as it meets the statutory requirements that are set forth in those provisions. So, for example, it doesn't cover the use of, if we have a student club, that the Harry Potter fan club on campus that wants to get together and have a Harry Potter movie marathon in a theater on campus, that's not a non-infringing performance. That requires a license, and believe me, we get those licenses when we need to do that. So we're not talking about all performances everywhere on campus. We're talking about the specific non-infringing performances that meet the conditions that are set forth in the statute. In order to make those performances, what we need, in some cases, is a full copy of the movie that sits on a server somewhere. And that copy, that's the copy I'm talking about, that's covered either under 112 or under 107.
So just to follow up, because that, as Mr. Williams noted, it implicates a right of reproduction. It's not just the performance anymore under 110. So when you look at 112F, Section 112 is subject to a statutory license, actually, and it doesn't apply to motion pictures. So how is it relevant to this proposed exemption?
Let me get the language of 112 in front of me. I'll defer to
sure.
others.
Or Professor DeCherney, while we wait.
Yeah, Peter DeCherney. I'm just thinking about the history of the exemption process and the history of fair use, and I realized 2006 is an important moment for both. That's when the educational exemption begins. It's also when the DK publishing case happens, and I think it's 2006. It might be. And for me, that's what really kind of when transformative use kind of crystallizes. And so we have all these ways of trying to bring the exemption process in line with fair use, focusing on short portions, comment and criticism. But as far as I remember, the word transformative doesn't appear in any of the exemptions. Maybe there's a way to bring transformative use into the exemption process without these other kinds of definitions and limitations.
Well, I'm not sure that we want to bring transformative use into it. I would think that, frankly, that we're saying it for educational purposes, that's already a recontextualization and repurposing that is more than adequate. I also think that although this discussion about exactly the bounds of what is infringing or non-infringing is interesting, it's really not that relevant, because at the end of the day, I mean, the existing exemption, the way it's worded, under the existing regulation creating exemptions, it says, that the prohibitions in Section 1201A1A shall not apply to persons who engage in infringing uses of the following classes of work. So ultimately, what is going to be determined, we don't need to go all, consider every possible permutation of what, how BYU decides to, where it decides to store things. I mean, if that's a separate question. I mean, if that's infringing, then they can be sued and be found liable for infringement. Here we're looking at what's happening, the end use. That's the real scope of inquiry. And again, if it's infringing, it's infringing. That's different from whether the circumvention was lawful or not. So again, as long as Mr. Williams' concern about, maybe this is infringing, maybe that's infringing. The point is, if it's infringing, it's infringing, and that's the end of that discussion. The other point I'd like to make is with respect to sort of making this entire exemption, or the educational pieces of it, more usable, is the restriction about requiring close analysis of film and media excerpts. And sort of like this requiring close analysis is a difficult standard for teachers in the field to apply. I mean, and they're trying to say, well, do I really require close analysis? You know, so it's like, you know, it has to be required and it has to be close. And those are hard standards to meet. And interestingly, you don't have those standards with respect to documentary filmmaking or non-commercial video. And so you have this kind of funny situation where if I want to do if a student wants to make a video or a remix for his own pleasure to put up on YouTube, he doesn't need to worry about, well, does this require close analysis, right? I mean, they can simply do it.
Sure.
But in the educational context, the same student, if he's making a remix for educational purposes, he has to worry about, okay, is this, you know, is this a class that is, you know, if it's a psych class, is it, I mean, there's really no reason to have this, you know, close analysis restriction, especially in light of the fact that, again, same people in a different context don't have it, and the likelihood of, it's one of these artificial distinctions that really doesn't benefit anyone, except just drive teachers crazy.
Noted. I think one of the reasons why that limitation is included, though, is because the record in the 2015 rulemaking, like those were the examples that were presented as actually needing to circumvent, whereas maybe screen capture would have been appropriate. So I think what would be very helpful, and perhaps Professor Hubbs can speak to this, is you've talked about like the needs are the same regardless of, you know, who you're teaching, but can you provide any specific examples where circumvention is required, and it's not just for close analysis of films?
I would be happy to, because of course, to prepare for this meeting, I went to my wonderful network and asked them to share with me stories. Here's an example. And it's an example of how Mr. Band is right about how the limiting language of close analysis is a problem. Here's a middle school teacher who is doing a unit on architecture, right? And the focus is, how do houses get built? She wants to use...
And I'm sorry, which grade is this for?
This is middle school. She wants to use a DVD of a film called Alone in the Wilderness, which apparently features a guy who's building a house. She's intending to have kids watch clips from this film so that they see the steps in the process, and then she wants them to essentially make their own how-to video. They're not really engaging in close analysis the way we would conceptualize it in media literacy education. They're not really analyzing the author, the purpose, the point of view, right? She wants to use these short portions to show steps in a process. It's a much broader conceptualization of educational media use.
And how would circumvention prevent her from doing that now?
So queuing up and using the 12 portions versus having a clip compilation tape with a room full of squirmy 13-year-olds in a 42-minute lesson, the best way for her to do that is through a clip compilation.
And why would screen capture not be a feasible alternative?
Screen capture might be an alternative.
Mr. Midgley?
Yeah, a couple points. I actually, the demo that I have illustrates.
I was thinking maybe we'd go ahead and do that. If we could please enter as exhibit, is it one? It's going to be 1E. It's going to be 1E as an elephant. It is.
I'm sorry. So this demo is a foreign language instruction demo we hope illustrates why.
The following demonstration shows some interactive tools which require circumvention of TPMs on DVDs or Blu-ray Disks. The demonstration was prepared using a DVD of Monsieur Batanol, a French-language film produced in 2002 by RF2K Productions. The TPMs of the DVD were circumvented to capture the French and English subtitles as separate text files. If we can capture subtitles as text files, instructors and students can choose to display the subtitles in French, English, or both during playback of the film. The subtitles can be turned on or off as needed to facilitate learning. If the same film were recorded using screen capture technology, the subtitles would be permanently fixed on the resulting video file and could not be turned on or off. Separately accessible text files also allow instructors and students to select specific words or phrases and use the selected text to interact with web services, such as online translation tools, to facilitate learning. With screen capture, the subtitles appear as images on the video, and a viewer would be unable to interact with the text. Another advantage is that the subtitle text files enable instructors and students to view a full transcript of the film's dialogue and control playback from a separate frame that is synchronized with the video. This feature allows a viewer to jump directly to any scene in the film and listen to the dialogue simply by selecting a section of the transcript. The screen capture technology just records whatever is on a screen. To have even limited access to subtitles of this film, for example, we would have to record it at least 3 times. Once with French subtitles, once with English subtitles, and once with no subtitles. For these reasons, screen capture technology is not an adequate alternative to circumvention for educational purposes.
I guess I didn't need to be standing here.
The following demonstration shows some interactive tools which require circumvention of TPMs on DVDs or Blu-ray Disks.
Mr. Turnbull?
Let me first say that, in my view, and maybe this is a drafting point, which I wasn't quite prepared for initially, but the point, that's exactly what close analysis relates to, in my view. In this case, isn't close analysis perhaps of the image of the faces or whatever, but it's close analysis of a part of the film. And so the existing exemption works perfectly well for this example. So I don't see what the problem is with that. Going back for just a minute, the whole premise that's been advocated by the far end of the table here it seems to me turns this proceeding upside down. The proceeding starts with the proposition that circumvention is prohibited, and then says, are there particular uses, non-infringing uses, that are somehow being prevented by a technological protection measure that then should enable circumvention for those particular purposes where the record has demonstrated them. And the education, all of the education provisions that we're talking about, except I think the MOOC one, which we'll get to, existed. Congress did not say circumvention is prohibited except for educational uses. Circumvention is prohibited except for fair uses. Congress didn't say that. Congress said circumvention is prohibited, period, and then went on to say, in certain circumstances where it is demonstrated that a particular non-infringing use is being prevented by a TPM, circumvention may be exempted, or the prohibition may be lifted for those particular uses. And that, it seems to me, from the standpoint of the technological protection measure provider, is absolutely critical to the statutory structure. And I'm sorry about it overrides some of the other provisions that are generic with regard to education, but it does, and that was the choice that Congress made.
So, Mr. Midgley, if I could, just because it seems that Mr. Turnbull seems to think that your example would be covered by the current exemption, so, and I know some proponents have expressed that the term close analysis is ambiguous, so is there perhaps alternative language that could be used that might appear to be broader, that would make people feel more comfortable?
Sure. Tie it to 110.1 and 110.2. That's the alternative language. That's the simplest solution to this problem. The current exemption would not, for example, cover, if you wanted to watch that entire film in a French class and have the instructor standing at the podium deciding to turn on and off subtitles as needed during the class, that is perfectly permissible under 110.1, the entire film, but the current exemption wouldn't allow that because it's limited to short portions. So it's, in its current form, even if we consider that to be a close analysis of film, and you may have noticed that the quality of that was not all that high. I specifically chose a film with fairly low resolution to illustrate that there are non-film studies situations where you need to circumvent, not because you need super high resolution capability, but there are other reasons why you need it in various educational settings. So from our standpoint, we're not here saying we need an eighth category now for foreign language instructors, because we've now brought that use case, and 3 years from now, I don't know who's going to be coming in next, our history professors and so on. I mean, that's taking the approach that's being advocated by our friends on the other side has led us to where we are right now, and as Mr. Band alluded to earlier, it's a completely unworkable mess. And so the solution here is not let's further subdivide and complicate and wait for more people to come forward and deal with very specific use cases. Rather, the solution is let's make the prohibition on circumvention match the policy that was already enacted for this very specific category of users. It's the nonprofit educational users, and that's it. It doesn't go beyond that. It doesn't cover all uses by those organizations. It covers very specific performances that meet the statutory conditions that are set forth in 110.1 and 110.2.
So we'll definitely talk a lot more about 110, but just as a preliminary matter, Joint Educators' proposed exemption asks us to completely eliminate references to Section 110, and you want that to be the guide. So how do we reconcile that if we're going to have a single educational use exemption?
You use your judgment. I mean, obviously, we've come forward with a specific proposal that we think addresses this issue, and again, we fully support the general notion that's being advocated by EFF and others that what is needed here is simplification, consolidation, to make it useful to the people who presumably are the intended beneficiaries. That's how we understand this rulemaking to be, and again, with all due respect, if you look at the legislative history behind the DMCA, again, nonprofit educational users were specifically called out. It's in the statute itself.
I hear what you're saying, but I think, we obviously have exemptions for educational purposes, realizing that there is value. So I think we want to do exactly what you're asking, but in terms of simplifying, and it seems like by having kind of a maybe broader educational exemption could potentially be that. I guess we're asking for guidance. If you have completely different conflicting goals, like how do we resolve those issues?
I would just, from our standpoint, our specific recommendation and proposal is the simplest way to address this is just tie it to the statutory language and conditions that are already there. There's safety in sticking with the statute. And so, although, we certainly appreciate other perspectives, and if there's another way that the office wants to try to bring the simplicity that's needed, we're definitely open to that. But our recommendation, for what it's worth, is just tie it to the statute. One other housekeeping thing. I was asked earlier about 112 and the provisions in 112A that were being referenced.
You referenced 112F.
Yes, exactly. And if you look at 112F, it doesn't have the same restrictions that were being mentioned about, excluding motion pictures and the need for a license. So anyway, I just call that to the
But it
attention
is
of
subject to a statutory license, so it's not like people can just go do this for free. Like, they are doing it so that they will pay a statutory license under Section 114, so.
This may require some post-hearing briefing, and we'd certainly be happy to participate in that. I just, to the extent that again, we submit that these copies would be covered under 107 anyway, but 112F is also there as another safe harbor for those
All right.
temporary copies.
Thank you, Mr. Williams.
Thank you. I can't say I've memorized section 112, but 112F seems to relate back to 110.2. 110.2 involves transmission of portions of works. What Mr. Midgley so far has been talking about, I think in every example, is whole copies of works. And so I'm not so sure that you can fit what he's looking to do into section 112, and section 110 itself does not specifically enable the copying. So I still think you have to go to section 107 to get where he wants to go, and I would submit that at least for some of what he's put forward, 107 would not apply. I think one of the issues here is whether he's talking about needing to circumvent to get digital copies in order to make the performances that he wants to make, and I don't see why he has to circumvent to create digital copies when he already has lawful copies that he's purchased that he can use to make all of these transmissions. I don't think that was in the record what he showed us just now, and so it's hard to process it quickly on the fly, and I'm not sure I understood everything that was going on, but I think what was done is a complete in the clear copy was made, and then they wanted to use it in the classroom to move back and forth between different languages and back and forth between either different scenes or different chapters within a disc. I think that's probably achievable with most discs.
I was also a little confused why you couldn't just use the disc as purchased.
And I think that's even more true
that.
of digital copies that you obtain through a streaming service, for example, where you can switch back and forth without, going back to the beginning of the movie or anything. You can just go into the subtitles menu, switch the language, and then move ahead. So I still don't think they've identified anything where they don't have a lawful alternative to engage in the conduct. Not wanting to have DVD players or optical disc drives in the classroom, for example, is not something that I think is reasonable, given that they're asking for an exemption just to avoid that. And so I do think that there are alternatives. I don't think they need to create in the clear copies to achieve what they've been showing us. And I also don't think that Section 110 or 112F expressly covers the creation of complete copies like the ones they want to create.
So, I don't know who would like to respond to what Mr. Williams said, but I think part of tying together with what Mr. Midgley said, part of our project here is to examine the availability for use of works for educational purposes in general. And so if access controls are impeding that availability for use, that would militate towards recommending an exemption. But are works already available for educational purposes, or if not, how are they not? If you can purchase a copy or stream a copy or download a copy or circumvent and their existing exemptions or with screen capture, yada, yada, yada. Is this impeding educational purposes, having what remains of the prohibition on circumvention? And if so, how?
So, related to that, and just, but I think this ties into sort of the discussion we've just been having. So, and certainly a lot of what we're really, interested in, and certainly what Professor DeCherny has always been talking about is sort of like these compilations. And as Professor Hobbs was saying, when you're in a middle school class, or even if we were trying to show something here, having the clip compilation will make it much faster to navigate as opposed to trying to zip back and forth.
Right.
Within.
Just try to, when we're going to come back and look at what we have to say, when we look at the second factor statutorily, how we consider it. So sorry to drill down on you, but I kind of want to do this with everyone. You can use screen capture techniques, and you can also use the temporary exemptions to make these clip compilations. So what is there a problem with
But
the
I think
current
we just
availability?
we just saw in that example that it's a language course. Screen capture would not allow you to make the kind of compilation with these different subtitles without going into much, much more work, okay? As you said, sort of like having to go through it 3 different times. So it's a much more efficient to just use circumvention rather than screen capture, and, you know, conceivably a better product as a result. But the further point is and this is, you know, we can't understate this, is operationalizing this in an educational context. And that is, and this goes back to, you know, Professor Hobbs' example with the middle school and the architecture. You know, maybe in that specific example, screen capture might be good enough. But then, you know, what about, again, what was going on in the language class next door? And they're not the ones doing the circumvention. It's some tech support person who's doing the circumvention. And so to try to have him say, okay, under these circumstances, you need to use this technology. Under those circumstances, you need to use other technology. It's again, unworkable. And
I hear you, and we're taking that seriously. We just want to make sure we cover all the issues, so if we can move on.
No, but I was just trying to explain why, sort of, even though you can pull one example and say, well, yes, that conceivably in the context of this room, we could say, yeah, that would work with screen capture. I'm trying to say, yeah, that doesn't work in the real world where you're dealing with people who are non-lawyers who have to, you know, the tech guy is getting 25 requests for making all of these compilations and then has to make these additional decisions. Is this close analysis? If it's close analysis, then it needs to be X. If it's not close analysis, then it needs to be Y. It just doesn't work.
Professor Hobbs?
So I wanted to, you asked about situations where the quality of teaching and learning is being impeded by the current language of the law. I want to speak to the part of the law that says short portions. Teacher came to me with this really interesting case study. She felt that under the current law, she couldn't design this activity, but here's what she wanted to do. This is a high school English teacher. You know, they just keep using Romeo and Juliet year after year. I don't know why, but this time she wanted to do a comparison between one of the classic versions of Romeo and Juliet and the animated film Gnomeo and Juliet. Have you seen that one? The animated one featuring the gnomes. But the thing she was working on with students was looking at rising action and the role of conflict and character in narrative structure. And so her plan was to have students create a visual map of all of Act 2, that's the middle portion of Romeo and Juliet, where students had to visually map the characters, the rising action, the conflict, and identify where was the culminating point in the narrative that then pushed it into Act 3. She knew that her kids would be interested in doing this challenge. She was trying to build digital literacy competencies in, so she wanted them to do this fully online. That is, they would be drawing the map online in their Google Classrooms. But she ultimately determined that perhaps using all of Act 2 was not what the law would consider a short portion. And so she forewent that opportunity. And I feel like that's an example of where the short portions restriction is limiting the innovation of teachers to make effective use of audiovisual media for learning purposes.
I would just like also to say that, I mean, it was the notion of equipping every classroom in America with a DVD player, which serves no educational purpose beyond playing this increasingly outmoded media, in addition to all of the logistical issues which have been mentioned, bringing in stacks of DVDs and trying to fumble with all that. Just the sheer cost is something I think that should be taken into consideration, candidly, that obviously the nature of these proceedings is a balancing, and we're balancing on the one hand the interests of copyright holders, and As a university, we have the utmost respect for copyright holders. We generate all kinds of content on campus, and we're training a whole generation of future filmmakers and creators in all sorts of spaces. And so we're not coming to these proceedings suggesting that the rights of copyright holders should be just ignored or disregarded in any way. But by the same token, they have to be balanced against the needs of users. And for nonprofit educational institutions, which are very budget-conscious organizations, often funded with public taxpayer funds, the idea of equipping classrooms with personal computers is hard enough, and that's a device that has a wide range of potential educational uses. And there are ample evidence in the record that computers increasingly are coming without optical drives in them, and so from our vantage point, it makes no sense to say that the balance should be struck in such a way that we want nonprofit educational institutions to be forced to expend millions of dollars to bring this one piece of equipment into the classroom, which has no function other than this one limited function, which admittedly would do away with the need for what we're talking about in very specific circumstances, even though it has the additional logistical costs associated with it. Again, something that we think should be taken into account. When you look at that whole picture, we feel that the record amply demonstrates that the balance can very comfortably be set in favor of the exemption we're proposing.
Well, just a quick follow-up question on the issue of cost. So, for example, like Section 108, which allows libraries to make replacement copies in certain circumstances, like if basically the technology is becoming obsolete, or the copy itself is becoming obsolete. But in that instance, libraries still have to make a reasonable effort to go out in the marketplace to see if there is, an unused version that they could purchase, obviously at a reasonable price. You're not going to expect to spend $3,000 on like a first edition book or something like that. But so if Congress foresaw like an obligation for libraries to do something like that, why isn't the same thing true for educational institutions?
So, again, it's simply a balancing act. On the subject of cost and turning to the topic of streaming services, that's another example that's been cited. Why don't we as institutions just go pay for streaming licenses for all of this content? And there are a couple of responses to that, but one of them goes directly to the cost issue that you talked about. In our reply brief, we included an article from some scholars who were looking at a specific case study at George Mason University, and in their research they found the average cost for a perpetual streaming license was $520 per title, $369 for 5 years, $297 for a 3-year license. And when DVDs are costing, $60 on average, you're talking about a different order of magnitude in terms of the cost. And whether or not that's an appropriate cost shifting analysis, again, we leave that in the judgment of the office, but certainly our position is if you look at the requirements for the rule, which talk about the underlying non-infringing uses, the performances we're talking about, and the circumvention that you need strictly to get to those uses, we think that's a very reasonable place to strike the balance, given the overarching preference that nonprofit educational institutions enjoy.
Thank you. Just following up a little bit on the cost, I assume since this is about circumventing DVDs, for example, that BYU has DVD players both on computers and perhaps, purchased separately. Probably if you've bought the DVDs, I assume at some point you've bought the players and maybe you're expanding or maybe they break and you need to replace them. I mean, have you factored, how much of a problem is it of not being able to pay the DVDs that BYU has already purchased? Do you factor in a budget line item to replace these optical drives? It's hard to understand how palpable of a concern, I guess, this is now.
Yeah, so what we brought forward in our initial comments was the decision that our university has made We filed jointly with our companion university, BYU Idaho. Both of our IT departments have independently concluded that we're phasing out DVD players. And again, I can't speak broadly for what
Was
other.
that conclusion based on we're phasing out DVD players and, how will we watch all these DVDs we've invested in for classroom use? Or what was that, was that decision made because classroom uses were going to be relying more on streamed materials or other materials?
I can't speak to the underlying budgetary decision-making process, but, you know, again, you have limited funds to furnish these technology-enabled classrooms, and the people who look at these issues very carefully and consider, you know, how much money should be invested in the projectors in the room and all of the, you know, the computer equipment. It isn't a cheap undertaking, and you know, when that analysis was done, the ultimate net conclusion that was reached was that the benefits of having the DVD players in the classrooms, you know, the costs outweighed whatever benefit there might be. That was the decision. And again, although we can't speak for what universities or K through 12 institutions are doing nationwide, we just point to the same article on the George Mason study, which found the same thing. It's difficult for us to imagine that we are an outlier in reaching this decision, given the overall national trends away from physical, optical media. And so, but that's the evidence that we can bring forward, what we're doing on our own campus and what we hear from what other institutions are doing.
So just a follow-up question to that, if I might. If you could describe for us how you're now going to take a DVD from your library, break the encryption, and then project that in each of the classrooms. How is that process working for BYU, and what are they thinking going forward, and how that's going to work?
Well, sure. It would. I mean, it needs to be developed, obviously, depending on the outcome of this rulemaking. But the thought would be that that these performances, we would undertake an effort to ensure that we're complying with, if our proposal is accepted, with 110.1 and 110.2. In other words, you know, contrary to the concerns that have been expressed, these whatever copies, intermediate copies would be made, would be very carefully controlled. It would not exist in the wild. Access would be limited to registered students in specific courses. For example, there's a range of technological measures that we might undertake to.
Section 110 specifically relates to like classroom use, so how would it be available to students outside of the classroom? If you want.
Oh, I'm sorry.
I'm just trying to clarify when you say it's available for students, are you really saying it's available for faculty to show to students, or what do you mean?
Oh, yeah, sorry. So 110.1 is related to live face-to-face classroom teaching. And so in that situation, obviously it would be individual professors, like these two esteemed colleagues on my seated next to me here, who would have access to make the performance that they would need to make in a live face-to-face classroom teaching situation. And that performance, of course, would need to meet all of the statutory requirements that are set forth. You know, it would need to take place in a classroom or a similar place devoted to instruction, for example, and well, all the requirements. In a 110.2 context, if we wanted to make a performance in that setting, then, you know, the systems would need to be developed that would restrict access to the students who are enrolled in the course and meet all. It would be in that setting, of course, we wouldn't be showing full movies because it's limited to reasonable and limited portions, exactly what the conditions are that are set forth in 110.2. So those systems would need to be developed, and we would just develop them in line with whatever the conditions are that are set forth in the statute.
So would that, so would that copy exist on one server, and then it would be streamed to any classroom that has that on their syllabus for the year, or how would that process? Do you envision that it's got one master copy sitting on a server, and then it's streamed, or how are you thinking that?
It's a good question. I mean, I haven't developed exactly the parameters of how that system might work, but something along the lines of what you're suggesting, I think, seems reasonable as I sit here, that we'd have a master copy sitting somewhere and make sure that the performance of that film is done in a way that complies with 110.1 in a face-to-face classroom situation.
So a follow-up question, if I might, Mr. Williams, if you can help me with this a little bit. Is there a licensing available for this type of thing for universities if they want a master copy of a work so that they could stream it to classrooms? Is that sort of service available today?
I don't know the answer to that, to tell you the truth. Bruce and David might, but I can try to get an answer by the time we're in LA for the hearings there. And I had some other follow-up, but if you had more questions.
I was going to call on you, so why don't you go ahead?
Okay, thank you. So I think Bruce put his placard up, and so I think he's probably going to address much of what was just said about the obsolescence of disc players and things of that nature. But there's no reason that every single classroom needs one. Not everyone's watching a movie every minute of every classroom, and so in every classroom all around the campus. So the numbers that they're throwing out about cost are nowhere close to what would actually be required, because what's done is you buy a certain number that meet your needs, and then you move those around. And so I think that's far overstated, but I'll let Bruce talk more to that. I think some of the misunderstanding that was just expressed about the scope of 110 is in part what we're concerned about, that you're going to have all these copies being made, and maybe they get given out to students, maybe they don't. That's a concern. But going back to something that Jonathan said earlier that I think is very important, and I can tell that of course everyone would prefer something simple, and that you're doing your best to look for a simple solution. But not every problem can be resolved in an effective way in one sentence. If you look at the provisions that we're talking about, Section 110, Section 112, Section 108, Congress has repeatedly tried to address real policy issues that require careful balancing, and quite frequently that requires some substantial drafting. And the notion that no one can make use of any of these exceptions because they're too complicated, I think, is flawed. I think these educational institutions are quite capable of analyzing Section 110 and deciding what they think is or is not covered, and that Congress has not tried to, throw up its hands and say if we can't get it done in one sentence, then nothing should be done. What they've tried to do is carefully balance out the equities and reach results that make sense for people. And so I think that's your job. The task that's been assigned to you as well is you have to analyze, are there alternatives? What are the lawful uses that we've actually been shown in the record? How quickly is this problem coming, if it is coming? Because I think BYU has said it's going to be several years before they implement this plan to stop buying disk drives, and they've not developed the plan about how to make the access available. It's clear. So I just want to emphasize that sometimes to get it right, you do have to draft something with some detail, and that's not necessarily a bad thing. And although I also wish that it was all simple, it's really not. Some of these things are complicated.
Mr. Turnbull?
Matt anticipated, obviously from our perspective, the viability of the DVD and Blu-ray formats is very, very much good and remains good and is expected to be very strong for decades, in our view. So now, and I would agree that the other thing is, if you don't want to buy the freestanding DVD player, the set-top kind of player, you can buy a DVD or Blu-ray drive that will connect to a computer, and so again, you don't need one for every classroom. You need however many you need based on what you think your likely demand is on any given day, and find a way to share them. So I both in terms of the utility and an external drive that can be connected through a USB port or equivalent, would work just as well as the standalone DVD player and might have other uses.
So, Mr. Midgley, maybe perhaps you can respond directly. Just opponents have essentially said that this adverse effect is of BYU's own making or decision not to purchase additional optical readers, and it seems like they are still available in the market. There are alternatives, so what would your response to that be?
Well, several things. First of all, it was, all the way back in 2006, and I think although we're participating in these proceedings for the first time, I understand, having reviewed prior proceedings, that the same set of arguments comes up every time, and every time the office, I believe, has found that the social costs of taking the time in class to fumble around with DVDs and queue them up and sit through copyright warning screens, which in general are my favorite screens of most movies, as the copyright guy on campus. I think that the social cost of that time that could otherwise be spent on instruction outweighs whatever benefits to copyright holders there might be by requiring a shared DVD player network on campuses or in K through 12 institutions. So rather than
can I clarify, because you're saying it's like it's taking away from like educational time. So is it not that there are not optical readers? It's more that optical readers take too long, and you want an alternative, faster way to show these motion pictures?
I think it's the cost associated with purchasing the optical drives, the time it takes to queue up what you're trying to do in the classroom, and if the solution to this problem is, well, you can save the money by taking more time by trying to wheel around DVD players between classrooms on a campus the size of BYU, I mean, I don't think that's a viable solution, frankly. And again, it's a balance. We understand that to some extent that there, I suppose, as a purely theoretical matter, a talented hacker or something could gain access and some infringing uses might occur, even though there's no evidence of that. And if that were to occur, then as Mr. Band alluded to earlier, then it would be infringement. And as an institution, any institution would be liable for whatever happens there. All we're talking about is facilitating the non-infringing uses that have been set aside in the statute.
One other quick follow-up, and then I'll move on. But BYU also talked about how, in its comments, that it was going to be kind of like phased out. You're just not going to replace any kind of machines that I presume break down. So what is the adverse effect now, and what is the likely adverse effect in the next 3 years? Because that's the determination that we have to look at here.
Sure. So I would say the adverse effect relates to the wasted class time that I was just alluding to. That's one immediate adverse effect.
But is that caused by a TPM? I mean... Yes. If the solution, what we're hearing from the other side is the solution to this problem is just bring the discs to class with you and play them using the licensed players that are sitting there in the classroom. Or if you don't want to spend the money on licensed players for every classroom, just buy a few and share them around the classrooms to meet your needs. That necessarily requires time to queue that up, and that time is caused by the fact that we can't stream the movies into the classroom in the way that we're talking about. I would just also, I think we've entered these exhibits in as well. BYU has been at this for a while. We were developing video discs decades ago, and
What is this that you have? I actually don't think.
I gave these to somebody earlier.
This is 1F.
1F. It's a.
Can you pass it around?
Sure, I'll be happy to pass it around. Okay. This is an old DVD player that was available years ago that was barcode enabled so that instructors could get to what you saw in that film, where people could get to specific portions of a movie by selecting the text. So BYU invested a lot of money in developing this foreign language, this Italian DVD, and the book that goes with it has individualized barcodes for every line of dialogue in the film. And the idea was that Pioneer was making these DVD players that had a barcode scanner, and you could scan the barcode and get to the film. That was all in an effort to overcome these challenges that I'm talking about, the wasted class time we're trying to get there. My point is simply that as an institution, we understand the need and the desire to go in through the front door, so to speak. We've been at this a long time, and we want to do it in a way that is compliant with the law. And the fact that this DVD player, which existed years ago, was actually referenced in the 2006 rulemaking and no longer exists today, is further evidence of the fact that when, as an institution, we make substantial investments relying on particular technology that's available at the time, only to find that within a few years that technology is no longer available on the market, it's gone away. That has real substantial costs. Not only in terms of the wasted class time that I'm talking about, but the money that was necessary to develop this kind of material. So for a variety of reasons, sort of being beholden to whatever the current technological or preferred media delivery format of Hollywood is, doesn't seem like it's the right balance to strike for nonprofit educational users, again, who enjoyed this preferred status in the statute.
Professor Hobbs, did you?
Okay, so I think there's a point that hasn't yet been made. You asked us to identify adverse effects, right? And I want to share a story about trying to find a DVD player at West Warwick Public Schools, where I was doing a staff development program for teachers. I was able to find one, but it took me about 30 minutes. At West Warwick High School, which is in a poor urban community right outside of Providence, the entire school district has moved to a one-to-one laptop situation. Every kid has a Chromebook or a laptop, and the expectation is that all of the learning resources that you're going to use are here on your laptop. So it was unusual for me to go to the program and say, I'd like to show you this clip in DVD. And they were like, oh, well, they did find one, but it's not normative, because the expectation is all of the digital resources that we need to use should be at our fingertips. The adverse consequences of this rulemaking proceedings is to maintain this idea that audiovisual resources are for transmission only, i.e. receive, view, watch. The generation of kids that are growing up today are using create-to-learn pedagogies, where they're not just watching, they're actually remixing and creating, that as part of the learning experiencing, as they are manipulating image, language, and sound. And so in some ways, that pedagogy gets stymied when the idea is, well, all of the motion picture content is only available through this one mechanism.
Can I ask you a question
of the
how
DVD?
It works in practice, because this came up the last time too, and now I have a child in elementary school. And she is also shooting. She is using the camera, and then she goes in and does all this create and learn, right? But so she doesn't need to circumvent anything because it is her content. Can you speak more about, in the context of this learning, why she would need to circumvent, or why it's necessary to circumvent TPMs on the Blu-ray, for example, to engage in this, as opposed to, in this type of classroom learning that you're talking about?
Sure, absolutely. It's great to hear that your daughter or your child is experiencing some media literacy pedagogy in the context of elementary education. What happens is, as children start to want to create more sophisticated products, they have to do what authors have done through all of human history. We quote from, we excerpt, we rely on the knowledge community. In building our own ideas, we use the ideas of other people. So it's very common that as we learn to do more academic writing, we learn to quote from an excerpt. And so for that purpose, remixing bits of motion picture media to develop your own ideas and your own argument is becoming a normative practice of quotation, just as it was for many years in writing academic essays.
Mr. Turnbull?
First of all, in order to do circumvention, you have to have a drive and a player. So to start out with, we're not, unless this is completely not about DVDs and Blu-rays, somebody in the school is going to have a drive and a player, because otherwise you can't get to the content on the Blu-ray or the DVD. So we're not eliminating them entirely. Second of all, the screen capture software that we used, David used, and presented in the exhibits that were submitted is free. So, and as he demonstrated in the previous panel, it's very easy to use. Now, in that panel, he was doing it into an ebook, but it could easily be done into video as well. So this is not expensive or complicated equipment that we're talking about as alternatives. And so, and if those don't, in the current K through 12 student example, it's limited to screen capture, but for the teachers, it's not limited to screen capture. If what you need to do isn't accommodated by the screen capture, and you really need the quality that's there, the exemption already exists. So we're arguing about a lot of things, and to go back to the 2006, I was here. I was the lawyer who presented the witness who demonstrated the Pioneer player. It was excruciating. And Professor DeCherney did an excellent job of dismantling us in that context. No one is proposing to use that product, and the exemptions that we currently have were as a result of the fact that the market didn't produce that product in a way that was viable and usable. But the exemptions already exist, and the point is that and the only point that we were talking about using a player, whether in a drive or a physical or a set-top kind of player, was if you were going to play the whole movie. And there you could queue it up and get past the FBI warnings and all that sort of thing before the class starts, and be all ready to play the whole movie if that's what you were going to do.
So a quick follow-up question, and then I do want to move to MOOCs just in the interest of time. So, Mr. Turnbull, so you seem to be saying, use screen capture when you can, unless you need some kind of close analysis,
right,
then you can circumvent. So if we were to keep those distinctions, would it be appropriate then to eliminate distinctions between educational levels? Like anyone in education can, if they need to have a close analysis, can circumvent, and alternatively can, if we could do that?
I think that we would say that the record doesn't support it for the K through 12 students. On the other hand, I understand, and I've heard the simplicity and the concern, and I've also heard the close analysis, and I think that there's probably, I can understand where there may be some confusion about that. To me, what that meant was, do you really need to see the close facial expression? Do you really need to see the closed captions, the subtitles, that sort of thing, or can you?
But if you do, and you're K through 12, would that be reasonable to have that available?
If that's what, if that's what the office decides that is a reasonable way to propose here, it's not something that we would propose, because we think the screen capture works for the purposes, those purposes, and we don't think the record has been developed to support the need for anything more than that. But
Mr. Brand, you've had your placard up for a while, so maybe we'll take this one last, and then we'll move to MOOCs.
No, I appreciate that, and this actually perhaps does follows from what Mr. Turnbull was just saying, and also what a comment Mr. Williams made earlier, and it's just to the point about, it is true that Congress in some of these areas has come up with very complicated exceptions, but 110.1 is the essence of simplicity. It's one sentence, I forget if it's 32 words or 36 words. Everyone understands it, and it's easy to use, and it's widely used. In contrast, 110.2 is, sort of the product of extensive negotiations between stakeholders. It's complicated, and it's not used because it has ambiguities, complexities, and so forth. And so that's why, sometimes it's hard to make it simple, but I think simple is better. And certainly, in this instance, the easiest thing you can do without doing anything else is certainly just collapse the four separate categories into one, sort of like the highest, I don't know if there's such a thing as the highest common denominator, but there's probably a mathematical term that's appropriate to that. And then, so that would be the first step, and then, make them all one, and then within the one, of the highest standards, so that would be probably the college and university one, then start making some of the other changes we're suggesting. It shouldn't be that hard, and that simplicity will be enormously beneficial.
Great, thank you. I think Ms. Kleiner, before we move to MOOCs, Ms. Kleiner had one question.
Yes. In her 2015 recommendation, the Register noted that the desire to engage in criticism or commentary was a critical factor in her recommendation to adopt the existing exemptions relating to educational purposes. BYU's proposed regulatory language eliminates the criticism and comment limitation. Why should the criticism and comment limitation be removed?
I'll take the liberty of responding to that if I may. It should be removed because it's not a condition of the statute. It's the purpose of the rule.
And when you say the statute, are you referring to 110?
Yeah, sorry. It's not a condition of 110. Again, the purpose of this rulemaking is to identify non-infringing uses, and this may be another example where lumping the educational users together with other fair users may have led to incorporating a limitation that's inappropriate for educational users. 110.1, the model of simplicity that was just alluded to, has no condition or requirement for criticism or comment. That shouldn't be a condition for the educational users. It may very well be an appropriate condition for other fair users. We're not really commenting on that. But our point again is simply to simplify, consolidate, and make it usable. The easiest way to do it is just align it with the statute, with 110.1.
Great, thank you. Mr. Turnbull, Mr. Taylor, you have your presentation relating to MOOCs. So why don't we go ahead and start with that, and then we can have some specific discussion.
Okay, here we are at the edX website, and I'm going to show you that the MOOCs we're familiar with in this proceeding do not include any technological protection measures. And to do that, I'm going to sign in with my Facebook account. When I created my edX account, I did not need anything more than my Facebook account, no student ID requirements. And right here we find the MOOC on the page, which is the MOOC will play back in this media player, and the MOOC is 7 minutes and 29 seconds, and we're stopped at 32 seconds. And right now we can see a picture of Professor Cheney talking to us from a movie theater. So I'm going to just play it back so that you can see the MOOC playing in the edX environment.
Remember it. Play it again, Sam. Here's what Rick actually says.
Play it for Harry, play it for me.
All right, I'm going to stop it there. And again, that was the MOOC playing back in the edX environment. What I'm going to do is show that it's very easy to
download the MOOC and play it directly from my laptop. To do that, I'm going to click on View Page Source. And this is the code here that produces the web page that we were just looking at. And I'm going to look for an MP4. And here we have an MP4. It is at edxvideo.net. And because I'm using Chrome, I can just right click. And we see that it's downloading automatically to my laptop, and it's down here in the corner. And when I open it up, show in folder, it's going to be in my downloads folder, which it is in fact here. And just to check to make sure that this is the same video, we click and look at details. You see that it is indeed 7 minutes and 29 seconds. That looks good. So I'm going to change the name of it to the MOOC exhibit. I'm going to move it to our desktop. And I'm going to play it back from the desktop. It's right here on the desktop. I'm going to choose Windows Media Player. There it is. It is the same MOOC now playing from my laptop outside the edX environment. Since it is on my laptop without any technological protection measures, I can keep it on my laptop indefinitely, and I can redistribute it as I like, including uploading it to a peer-to-peer website. So that is all I have. Thank you for your attention. Okay, here we are at the edX website, and I'm going to show you that the MOOCs we're familiar with in this proceeding do not include any technological protection measures. And to do that, I'm going to sign in with my...
I'm sure we'll have something to say.
I have some questions too, if you would like to know where to start. Do you want? Yeah, so we did not receive an opposition to renewing the current exemption for a MOOC, and it seems like, so what are we to make of your presentation where it seems Mr. Attorney, made use of the current temporary exemption? That was fine. You showed how it can be saved to your desktop. Can you just tie this into, is it going to the existing exemption or towards the expansion, which he's asked to take it out of edX, which doesn't seem as directly relevant to your presentation, and to also remove other restrictions on the Teach Act, which I guess, again, what the edX that you saw was within the bounds of all these limitations that are already there.
Well, to be frank, we discovered this as we were going along, and if we had known about it at the time that the renewals had come up, we would have raised an objection then. But in the course of this proceeding, we looked at it and looked at the evidence, and it occurred to us that this doesn't seem like there's a technological protection measure. And when they insisted that there was, we in fact are now demonstrating that there's not. We think that as far as
so you're saying
current, just let me finish one thought. As far as looking at expanding the exemption, I think it's even more troublesome to operators who we don't know. We may have more faith in Professor Duchesne and his course and being within an institution than with some other, any provider doing anything.
Either of you want to speak? Okay.
We're actually in new territory since this is the first year in which we've been able to work through renewals and have opposition before the hearing. So I'll let you guide us on how to work with that. But I'm happy to see that Mr. Taylor is now an enrolled student in my course because he had to do that in order to view the video. We actually, as far as I knew, downloading had been disabled. There's obviously a workaround, and I will send an email to edX immediately after this.
Okay, could you talk a little bit more about that? Your understanding was downloading had been disabled?
So most edX videos actually have a button and allow you to download material and allow you to download just the audio, and they think this is an important, I agree, it's an important aspect of creating access. People, the people who have the most trouble accessing it with the slowest connections need to download videos. So but in order to comply with the last rulemaking, we instructed edX that downstream misuse was something to be careful about, and that downloading had to be prevented. So I'm actually a little surprised that it's possible.
And just a follow-up, how would you respond to the concern expressed that, obviously this was like a section 110.2, like of having a TPM or something to protect the MOOC from this happening. What do you say to the concern about your wanting to remove all kind of section 110.2 limitations? And, is this going to happen again, or is this going to be more prevalent by other professors, not you?
Yeah, so we haven't asked to remove all section 110.2 limitations. We would like to expand the we'd like to expand the exemption so that it includes for-profit institutions and unaccredited institutions like Khan Academy, but we are still okay with limiting access to registered students and to preventing reasonable prevention of downstream misuse.
Okay, because you do say that the Teach Act limitations should be removed, so.
Yeah, okay.
So you're not talking about all.
Some, but not all.
Okay, that is a good clarification.
Maybe if we can hear from Mr. Band and then let Mr. Taylor sort of respond to both issues.
Just a couple of quick points. First, with respect to that example, I mean, it could very well be that that they have not applied in this instance a technological measure that reasonably prevents unauthorized further dissemination. And if that's the case, then the recourse is to for the rights holder to for Humphrey Bogart to call up edX and say, okay, there's a problem here, and then edX has to deal with it. I mean, the problem is not with the exemption, it's with what someone is doing, whether they're complying or not complying with the exemption.
And am I correct, no one is trying to remove that language from the exemption of applying technological measures that reasonably prevent unauthorized further dissemination? Everyone is nodding at me. Okay.
I guess the second point with respect to that is, at least to me, that was kind of complicated, meaning that was a lot of steps. Not that easy. I mean, certainly I would not be capable of doing that. I mean, anything more than 3 steps is beyond my capability. And I would also say, yeah. But I would also submit that I'm sure that someone in this room who is much more technologically capable than me can find copies of Casablanca, the greatest film ever made, by the way, but could find copies of Casablanca, available from many sources, and it would probably take a lot fewer steps to download than all of the steps taken there. And so, again, let's be real here about what the real adverse impact, I mean, how many people are likely to want to download the 7 minutes from this MOOC when they can, within, again, I'm sure someone here is already Googling it and finding, the website where I'm not defending that, I'm just saying, again, why, we shouldn't make it so difficult to have educational uses when we know that this isn't how they're going to access Casablanca. No one's going to is going to download the 7 minutes when they can get the whole thing for free somewhere else with 1 step.
Mr. Taylor?
Well, I think the problem is that it creates a question of fact for the offender down the road, that you're giving them this larger shield, and a judge you're going to have to litigate that issue. Do you qualify underneath the exemption? So I don't necessarily think that, I do think that there is a significant harm there. And I just want to clarify that I am not an enrolled student in Professor DeCherny's course. All I needed was my Facebook account, and I was logged in. And as far as the difficulty, there were not, other than logging onto the site, it was literally 3 steps.
He is absolutely an enrolled student in my class, and if we had a few minutes, I could look up his exam grades if he took any of the quizzes or participated in discussions.
And he also probably breached the terms of service, so.
Okay, I'm going to refrain from making a joke about Facebook today. So, Mr. Midgley?
I think there is an important point that was alluded to, which is in the end, I think one of the goals of this proceeding should be to try to match what's happening on the ground what the expectations of modern students and instructors are when they arrive on campus. This is a generation of folks who have been raised experiencing media primarily through streaming services. I mean, that's just the reality of the situation that we find. And so if this set of rules becomes so complicated that students and instructors just reject, they look at it, they feel like it's too complicated, I don't want to mess with it. The alternative is a much worse state of affairs. You know, the piracy concerns and other things that I think are legitimate worries of content owners, I think are going to be exacerbated, not helped by making this set of rules more complicated. It's easier for people who sit in chairs like mine. You know, I'm the copyright officer for my university. I'm trying hard to get students and professors to follow the rules, to go in through the front door. And the more straightforward and easier that is, it's easier for people like me to do our jobs. And the more complicated we make it, the result is not that people just forego the experience altogether. They find other more troublesome ways of solving the problem. And I just feel like that needs to be said.
Sure, and just to be clear, we're not trying to make things more complicated. We are definitely hoping to have something less complicated at the end of this rulemaking. But I do want to ask a few questions, and they will be directed to you, Professor DeChaney, but because they are specifically about MOOCs, so you can respond. I know you had your placard up, but so Professor DeChaney, can you provide any examples of specific MOOCs that professors want to use at for-profit educational institutions, but cannot under the current exemption?
Yes, great question. Thank you. I just want to say that the last exemption for MOOCs has made a really palpable, tremendous difference, right? So this course could not have existed before. I told you I would not have created it unless you created the exemption. You did. It took me 9 months of doing very little else to create this MOOC. Over 30,000 people have taken it, around in 170 countries. The very first comment on the discussion board was from a father who said he was homeschooling his children, he always wanted to offer them a film course, and he finally could. A harm I didn't even know existed. Several other universities have created courses using the exemption since, and so it's done a great job already. Increasingly, the lines between for-profit and non-profit educational institutions are blurring. The kinds of resources that are being used are being mixed by accredited and non-accredited institutions. Something Renee was starting to talk about earlier was the flip model of classrooms, that increasingly lectures are being put online, and in-class work is more active, more activity-based. And so things like Khan Academy, lynda.com, these unaccredited, one for-profit, one non-profit institution are actually creating resources that get used more and more in accredited institutions. So let me give you one example through Khan Academy. Right, most people here have used Khan Academy, most likely for a math or science video.
Sure. Okay, so we can talk about Khan Academy because that specifically goes to unaccredited, an educational institution, and you did reference it. But are there any specific MOOCs that Khan Academy wants to offer but cannot? Like we saw it referenced, and it has an online education, but how is it being prevented from offering that education due to TPMs?
Yeah, so if you look at their courses on history or art history, you'll see that they only use public domain material, they only use still images. They have a section of videos about the filmmaker Ken Loach and Christopher Nolan, and they talk about how they've been influenced by Hogarth and Francis Bacon, respectively, and you would expect to see a film clip in a half-hour interview with Christopher Nolan, and yet there are none.
Have you spoken to any professors at Khan Academy who want to offer MOOCs but who cannot, or is this just you're looking at?
I assume that the reasons they are using public domain material and still images and not film clips or more recent material is that they can't.
So you just looked at their website, you haven't spoken to anyone?
We haven't spoken
Okay.
to Khan Academy.
And have you spoken to anyone at Full Sail University, which was an example of?
No, so I have spoken to people at Duke University and the head of their online programs. Duke has an MBA program in which they have online courses. They offer MOOCs. They offer, obviously residential courses to MBA students. They have a for-profit executive education wing in the business school, and they can't offer the same kinds of lectures that they can offer to students who are enrolled in a course.
And I appreciate that you say that they cannot, because the exemption doesn't extend to for-profit and it doesn't extend to unaccredited
Right.
educational institutions. I think because we have to create a record of concrete examples. So do you have any concrete examples by having spoken to professors or seeing professors say online that they want to offer a specific MOOC at an unaccredited institution or at a for-profit institution? I think concrete examples of those instances would be most helpful.
Yeah, okay, so these are in some ways opportunity costs. That was being discussed at in the last panel, right? Whole genres of documentary films weren't being made for years until the best practices and documentary film statement was created. E&O insurers started to accept it, and then all of a sudden we started to get more history films, more films that used archival material. I think we see the same things in the MOOC world. It's not a coincidence that all the MOOCs that took advantage of the last exemption over the past 2.5 years have all been offered by accredited nonprofit institutions. For-profit institutions, unaccredited institutions can't take advantage of it. They haven't been the ones to create the courses.
So perhaps one of the opponents could respond to this, but would it be reasonable to expand the exemption to for-profit educational institutions?
I mean, there doesn't seem to be a demand for it. I don't recall seeing anything in the record from any of them. None of them are here to testify in support of it. I appreciate that Professor DeSherney is passionate about making sure as many people can be included as possible, but I think what you're confronted with is what's in the record that shows us there's a demand to engage in a certain type of use, and then if there is it non-infringing, are there alternatives, et cetera, and I don't see that the demand has been presented. Section 110 does refer to nonprofit institutions, so that would factor into the analysis to some extent. I think a bigger concern for me is how far does it go? I've only heard Professor DeSherney so far talk about actual institutions, but I didn't gather from the comments that this was really bounded in any way. So what qualifies as an educational online use? What qualifies as a registered student if you're just someone who's opened up a blog and says anyone who logs in, I'm going to help teach you about something? It seems contourless, and I think the way that you've traditionally drawn contours into exemptions is by seeing who has put evidence into the record and then looking to define the exemption accordingly. So I think that's still how it should be done here. So I wouldn't change the way it's drafted now.
And so your position would be the same with unaccredited institutions?
That's my understanding. I don't think any have put anything into the record. If they did, I missed it. I know that there's a number of organizations on the joint educators' comments, and I don't know who all of their members are.
Great. So kind of going off of something that Mr. Williams just mentioned is just how to define an online course. So perhaps Professor DeSherney, you can help us with this, but where's the line between an online course, something that could qualify as a MOOC, something that you do, versus something that's arguably an instructional video on YouTube?
So there are a number of issues, I guess. One is there are organizations of for-profit educational institutions and unaccredited institutions. Some of them overlap with societies and groups that also represent accredited nonprofits. So the groups of faculty or organizations that are part of the Joint Educators. Many of their members are also teaching at unaccredited institutions or for-profit institutions. So they are in some ways part of the record. What is a course? That's something that's evolving.
Or an online course, because you want to extend the exemption to all online courses, so how would we go about defining that?
Yeah, I wonder if in your answer, I'm a little confused as to what you're advocating for. Is it all online courses, including if you're for-profit or non-accredited, or is it all online courses? You don't need to log in. There doesn't need to be any type of instructional component. It could be something on YouTube that's educational generally.
Yeah. No. So we are proposing all online courses. We still think that there should be a limitation to registered students, and there should be a reasonable attempt to stop downstream misuse. And of course, edX will get a call immediately after this to make sure that they are complying, that we are complying. But what is an online course is something that's obviously changing and expanding. So through places like edX and Coursera and Udacity, they're actually expanding in the other direction now, offering larger full online degree programs. They're also offering smaller and more modular courses, things that are shorter, that might only take a week rather than a full semester. This is the way that online education is going. Increasingly, they're offering skills. This is what students are asking for. Millennials change jobs, every few years, and are looking for shorter skills-based courses. We provide some of them through Penn, but many others are offered through these online platforms. Sometimes through Google offers IT courses through Coursera these days. So there's definitely an array, a continuum of courses, from some that are very short to some that are now multi-year degree programs.
Professor Hobbs?
I agree with that, and I would suggest that the critical dimension is the concept of a registered user. I myself offer online courses in the form of online formal courses through the University of Rhode Island that students have to sign up for to take online, and my students come from all over the country. But I also offer webinars. And a webinar, no one needs to register. They click to enter the video conference space, they exchange information, and they receive information just as a student would. They're learning. But I don't consider it a course because I don't register them, right? It's come as you are. And so I think that one way we could define, pretty clearly about an online course is students are registered. It's not whether they pay, right? It's whether they register. And so
But registered where? Like registered with a university? Like where is
submit an email identification. That would be registered.
I mean, that may be more onerous than the edX example now, where you just need to click through your login, your Facebook login, and you're in the edX program.
Sure. So a Facebook login would be a form of registration. You're still supplying whereas in my webinar, you don't even need to do that.
All right. So, I think this may be fine. This may be what you are. I just want to understand your view of how the world would work. I think probably most people, when they watch on YouTube, are logged in to sort of keep track with what they're watching. I think that's how they're advertised against. So as long as it's educational, would that qualify? Or would that not be a course? Because I think a week-long course, for example, might be permitted under the current exemption.
Only if it's an accredited,
tied to somebody
nonprofit, yeah.
Yep.
But something like, if you want to take the history of Western civilization through Khan Academy, that would not be okay. And you could look at public domain material, still images, but at some point, no videos, and the 20th century gets short shrift. Same thing with something like lynda.com.
I don't know that there's videos, for prior centuries either.
Right, no, exactly, yeah. So lynda.com, actually a very helpful educational resource. Something that's been interesting to see at my university. Subscriptions have been small and localized, and now everyone in the university has access. It provides skills-based training that's often used as a kind of supplement to existing on-campus courses, but it's a for-profit owned by Microsoft, and so they offer film courses, they offer lots of courses that deal with media in different ways, production courses, and those are not obviously covered by the current exemption.
Mr. Williams?
Thank you. I think we've kind of lost sight of what's in the existing exemption with respect to enrollment, because it applies to accredited nonprofit educational institutions to officially enrolled students. I think the intent there was to say in those institutions, not just that someone signed up for Facebook and that means they're officially enrolled. And so Professor DeSherney is saying that David is officially enrolled now at University of Pennsylvania because he's got a Facebook account and can click through that website's terms. I don't think that's what was intended by the existing exemption. You could tell me I'm wrong, but it applies to students who are officially enrolled in the nonprofit educational institutions. And I don't think just by clicking that button, David became a UPenn student.
So you'd be surprised if you went across the street and found out how much information Facebook has about you and how much we now have as part of your enrollment. Even though it was even though it was easy, you've actually enrolled in the course, which is offered by an accredited nonprofit institution. You're not a student of the University of Pennsylvania, I'm sorry to say. But you are a student in my course, and you can interact with students from all over the world and have discussions about media and history. We have, burgeoning filmmakers who will be members of your associations very soon, and so that the course is offered by an accredited nonprofit institution. It doesn't mean you're a student at the institution. We actually call you a learner. You're there to be part of the course, but you don't get the services that a student at the university would get.
Also, if I just might add, the exemption applies to massive, open, online courses. Okay, it's understood that it's an open, massive course. That's not, it's not an online course of students who are enrolled at the University of Pennsylvania. That's a totally different category. It's everyone knows what a massive open online course is. That's why the term was used by the Copyright Office.
I would just like to
Mr.
address
Chair.
that. Sorry, David Taylor. When we did this exemption last cycle, they came to us with the term MOOCs, and that was the term that they used. And after that, there was the imposition of the teach requirements on it. And I think it was just a legacy issue. And as Mr. Williams already suggested, the understanding that we had developed certainly was that they were supposed to be enrolled at the institution and that you were not having a worldwide event. But what I also wanted to say is that as far as Khan Academy, just because Khan Academy cannot take advantage of the exemption here doesn't necessarily mean that they don't have exciting courses like Professor DeCherney's. In fact, they do have a very amazing course on movies and film industry and video processing that's been put together by Pixar. So even these institutions have similar, or if not better, programming available to them without the benefit of the exemption.
I guess just running through a few, because we're kind of talking about some of the Section 110 requirements. So, Professor DeCherney, so just to confirm, you believe it's reasonable to keep the officially enrolled students limitation? You believe it's reasonable to keep the short portion limitation? You believe it's reasonable to keep the limitation requiring the instituting of copyright policies and providing copyright informational materials to faculty, students, and relevant staff members?
Yes.
Okay. And you believe it's reasonable to keep the limitation that under the actual supervision of an instructor as an integral part of a class session offered as a regular part of the systematic mediated instructional activities of an educational institution? Okay.
That's actually one I sometimes can be confusing to interpret, but basically, yes.
Okay.
And I'll just say, our students who are already enrolled at the university taking online courses were protected by, or have been protected by 110.2 since 2001. In the last rulemaking, we expanded that, I think, to students who are enrolled in MOOCs. And now I think we're discriminating against universities, institutions that operate for profit and are unaccredited, and sometimes actually serve the students who have the hardest time accessing education. And I'd love to expand it a little bit more so that those students and other faculty members could be included.
So I guess that's kind of a follow-up question, because you do talk about how online education has, there's this huge increase in online education and it's really important. But if the online education is flourishing despite the fact that certain institutions are not covered by this exemption, like why is this circumvention necessary for those institutions if they are able to be successful without it?
They are, but we're pointing to holes in the kinds of education they can offer. They can offer great math classes. They can actually offer terrific film classes if they're Pixar. But not if they're not using content they already own and have created and are a major studio. In fact, the biggest studio in the world.
Great. So I have a couple questions relating to kind of going back to BYU a little bit. Alternatives to circumvention. So we have services such as Voodoo, or redeem codes. So why are those not sufficient alternative to circumvention?
Yeah, great question. A few reasons. First, the offerings through those services are limited. They're generally directed at more mass audiences, where educators often have very specific niche kinds of films that you can't find. So, for example, at BYU, we have a huge foreign language program. We have a Tahitian class, and the desire was to show Moana in Tahitian. Well, Moana's available on Netflix right now. That's great, but not in Tahitian. And so, you can get that movie and have it on DVD and use it in that form. But there's an example, and there are many, many examples. Having looked at the thousands of films that our foreign language instructors have requested over the years and trying to compare it against all of the online streaming services of which we're aware, it's only a small fraction that are available through those services.
So so is Moana available in Tahitian anywhere, or are you creating? Okay, so you're just saying it's just not available it's available on a DVD that you claim you can't play because you don't have optical readers? Like, I'm trying to understand.
No. I'm just giving that as an example of a film that's not available through a streaming service. Even though Moana is a very popular film, the version that we need for use in the educational setting we can't get it through Voodoo or Netflix or anywhere else. And there are many, many examples. I could go on there. So that's one reason that streaming service is not a viable alternative for us. Another reason are licensing restrictions. It's a fairly common practice, actually, for individual instructors to wander into a classroom, log in with their own personal Netflix credentials, and start streaming Netflix content into a classroom. The performance that's happening is non-infringing under 110.1, but there's a decent chance that individual professor is in violation of their personal terms of use that they've signed with Netflix, and attempts to reach out to Netflix and other streaming providers to try to negotiate large institutional licenses to try to address this issue so that, again, we can, universities are accustomed to paying ASCAP, BMI, other large performing rights organizations for the rights to perform on campus, but for at least as of right now, the streaming services, you can go just one by one through them. None of them offer licensing that's available that's appropriate for our kinds of use.
So why, if the teachers are not allowed to basically use Netflix for the purposes of 110, which it sounds like what you're saying, why are you seeking an exemption that extends to internet streaming services? Wouldn't in that case it be more appropriate to limit the exemption just to DVD and Blu-ray?
Yeah, no, what I was saying is that I'm just addressing the question of why streaming services are an inadequate alternative to circumvention.
Right, but you're also asking for the exemption to cover internet streaming services. So
Yes.
if that in and of itself is not a possibility for teachers to use, why should the exemption extend to internet streaming services?
Oh, well, there's certain content that's only available through streaming services. That's another phenomenon that we're seeing. Increasingly, we found over 75 documentaries, for example, that are only available through Netflix. You can't get them in any other way.
But aren't you just saying that the Netflix, the teachers aren't allowed to use that because of contractual issues?
Yes.
So I guess my question is, like, if you're not able to because of contractual issues for internet, I don't know if all internet streaming services, if you're seeing that it has the same contractual limitation, but if so, then why should the exemption extend to services that you are precluded from using under contractual?
Well, that's not a copyright issue. Again, I'm responding to the question about why the streaming services are inadequate as an alternative to circumvention. So the reason that we're seeking an exemption to cover certain content that's available through streaming services is because it's the only place where that content is available to us. And, that's a question for our general counsel's office to decide whether they're comfortable breaching a contract in a particular case or trying to work out an agreeable contractual relationship with the streaming provider. To facilitate the non-infringing, from a copyright standpoint, the non-infringing performance that would be made of the content that's available that way. But as things stand right now, there is no perfectly safe legal mechanism that makes guys like me happy. We're certainly familiar with this phenomenon that's going on campus. We know about it, and frankly, Netflix and other streaming services, they're aware of it as well, and everybody right now just sort of seems to be looking the other way. But again, that's the point of this proceeding. We're trying to bring these issues to the fore so that we can deal with them.
Sure. Just in the interest of time, because we are already
Sure.
over, Mr. Williams, do you have a response to?
Yes, just very briefly, and I'm not here representing Netflix, but as was described, the issue there is a terms of service issue. It's not an issue that's being caused by Section 1201. So I don't think that justifies an exemption. You have to look for things that are being caused by Section 1201. And then it's a little bit of an odd suggestion because on the one hand, they're requesting an exemption to hack the service, which is also a terms of service violation, obviously. But they're doing that because they don't want to violate the terms of service by just playing it in an authorized manner and then having to get into whether it applies to an institution versus the individual. So to me, this is not an issue caused by Section 1201.
Thank you. Just a few quick questions about the market. So BYU, you stated in your comments that instructors regularly make non-infringing performances of motion pictures in a wide range of educational settings. So if that is true, why is an expanded exemption necessary?
Yeah, the point is, right now, the current exemption draws a distinction between film studies courses or other courses requiring close analysis of films, and that statement that you just cited was offered in support of our position that trying to carve up the world of audiovisual works around a film studies limitation that doesn't exist in the statute is not helpful, because in foreign language classes, like we demonstrated, in history classes, in a wide range of classes, there are a different set of rules that apply. So that's the reason why a broader exemption is necessary, to make these works available in a way that's clear to educators across a wide variety of disciplines, and do away with these artificial distinctions for film studies professors.
Okay, just because you say you regularly make non-infringing performances, so I understand you're talking about a wide range of not just maybe film classes, but you're talking about how they are currently making performances. So if they are able to regularly make those performances, why is an exemption necessary?
Oh, for all the reasons we were discussing earlier. These performances are being made in suboptimal ways, by fumbling with DVDs in the classroom or being limited in certain ways in other ways. So exemptions are necessary to facilitate learning, like was demonstrated in the example that we provided.
Great, thank you. Mr. Williams, a few questions. So there's been some, I guess, in public articles about Disney Movies Anywhere kind of going away and the creation of like a larger Movies Anywhere. I don't know if you want to talk about what the future of Movies Anywhere is, like if it's sticking around or going away. That would be great to hear about, please.
Yes, and we have a witness from Disney who will present on Movies Anywhere in Los Angeles, and we tried to cover this in our comments. Essentially, there was Ultraviolet at the 2015 proceeding, and there was a large number of participants in that, and then there was Disney Movies Anywhere, and Disney had its own cloud service essentially, and different retailers. There was some overlap, but different retailers operated with one or the other. And essentially what has happened is almost all of the MPAA members, you can now get their titles through either one. And so Movies Anywhere has expanded in its reach, and that means that titles are available on more retailers than they were 3 years ago. Now iTunes and Google Play that we're working with Disney Movies Anywhere, other studios' titles that are purchased through those retailers can be accessed through Movies Anywhere. In most cases, they could also be accessed through Ultraviolet, depending on which retailer you buy from. Vudu, for example, you could go to either one of the two platforms. And there are additional participants beyond MPAA members alone in Ultraviolet, and I believe in Movies Anywhere as well, if I recall. So it's not that it's going away, it's that Movies Anywhere expanded its reach, and Ultraviolet is still there. There's still a number of retailers and studios participating in that as well. So the Disney witness will try to provide more detail on that.
Does Movies Anywhere offer Moana and Haitian?
I will make a note to try to look into that. I imagine that's potentially a regionally specific offering based on demand, but given the nature of the film, which I haven't seen, I've only seen clips of it might be available just because of the nature of the movie. But these cloud services really do provide a pretty unthinkable level of access if you go back to what we had before Section 1201 was created. They're exactly the types of things that Congress wanted to come about, and they are coming about. You can buy a copy in a variety of ways. You can buy it in the store, you can buy it through a digital retailer, and then you can move it into not only Movies Anywhere or Ultraviolet, but say you bought it from Vudu, you move it into Movies Anywhere, and you want to access it through your iTunes account, or your son or daughter wants to do that. It's available across multiple retailers, so that different people in the family who use different devices or different services can access the same title. So there's a lot of benefits there to those services.
Just while we have Mr. Williams talking about this, I'm just curious if they're available to be licensed for educational use.
Yeah, my understanding is they probably are in the terms limited to personal use. We've talked about that is not a Section 1201 issue per se, but there is a contractual issue there. So Mr. Midgley said that he had been reaching out to try to get licenses. I am not aware of those discussions, so I can't speak to them.
Great, and
And
one
of
last.
course, the other point, just to reinforce what Mr. Midgley was saying, that the vast majority of films are not sort of distributed by the major motion picture studios. We have many, many foreign films that that we need in educational context, or older films. So it's many of the newer films might be available, but not the older foreign independent films that are so essential. So again, it's a matter of what's available.
Do you want to speak to that, Mr. Williams, the back catalogs or moving beyond the major studios for these
Yeah,
services?
just very, very quickly, because I know we're over. We tried to address this issue of back titles in our comments, and we pointed to a number of online services where you can get older titles. You can get a lot of older titles in Movies Anywhere, in Ultraviolet, because they're being sold by the retailers, by Amazon, by Vudu, and they're available on disc and can often be converted up into those services through disc to digital. With respect to foreign titles, it used to be that people would make an attempt in the proceeding to put titles in the record and say, we can't get a number of titles that we want. That's just not been done. And so it's a little hard to respond at this point in the proceeding, because we do try to go through the comments and look for titles, because frequently people say, I can't find this anywhere, and we find it pretty quickly. So it may be true that there are some titles out there that are not available through a digital retailer, but I don't think there's any in the record that I recall.
One other question, Mr. Williams. So regarding MOOCs, or actually if Mr. Turnbull or Mr. Taylor want to comment, but would the size, openness, or other distribution aspects of a MOOC create a greater effect on the potential market for the underlying works, and if so, how?
I think, yes, that is an issue that would need to be looked at if you were analyzing the fair use factors. How many people are getting access to a work? Of course, you'd have to apply all of the factors and look at the purpose of the use, how long was the clip, a variety of things. But yes, the broader the reach, then the larger potential impact. Especially if you remove, the limitation that requires some protection measures to be in place.
Thank you. I have two questions. Mr. Midgley, I'll go ahead and ask you, since you raised your placard, I have one question for you. So if your proposed exemption relating to Section 110 were adopted, how would it differ from the current MOOC exemption that we already have?
Let's see, I would have to pull up the specific language to answer that. I was just going to say, if there is a desire, we'd be happy to furnish a list of movies that are unavailable to us in post-hearing briefing. It would start with Star Wars in Navajo, incidentally. I'd love to find where we can get that.
Sorry, get it anywhere or at all?
We have a DVD, a licensed copy of Star Wars in Navajo, but
okay.
It'd be interesting to see if that's available for us for digital purchase through Movies Anywhere or another platform. Anyway, but the broader point is I'd be happy to furnish a much longer list if that's something of interest to the office.
And maybe while you're looking at your notes, so Professor DeShaney, you state that incorporating, in your initial comments, you stated that incorporating Section 110.2 into the existing exemption limits the scope of the fair use doctrine. Can you provide specific examples, what you mean by that?
Yeah, so as you know, it's a safe harbor, but outside of that, there are lots of uses that could be fair uses that wouldn't be covered by Section 110.2. Right? It says at the beginning these are uses that are non-infringing.
But can you give any specific examples?
You have a good example?
Well, again, it could be something that's longer than a short. I mean, it might be something that might be longer than a short excerpt, but it could still be, for purposes of commentary, criticism, and again, obviously, it's a different purpose because it's an educational use. So, I think it would be it would comfortably fit within fair use, but it might not fit within 110.2.
So just to come back earlier, a lot of the same comments, I would say, our proposal would do away with a lot of the language that's in the preamble. So it's not the MOOC-specific language, but sort of the current very, very top of the rule that makes use of criticism and comment and short portions. That language we feel like are unnecessary limitations. So those are inherent in the MOOC specific subsection. That's one major difference. Another would be the, officially enrolled students. That's not a limitation of 110.1. And in general.
Well, but it is for 110.2.
Yes. So the idea is that you would, any non-infringing performance under either 110.1 or 110.2, the specific performance at issue would have to meet the requirements of that specific section. But to try to limit your 110.1 performances to all of the conditions for 110.2, we think is inappropriate.
Well, I guess I would more specifically think about the difference between the MOOCs exemption and your proposed exemption under 110.2, because those are both dealing with distance education.
Okay. Yeah, those are much closer, other than the preambles that we just mentioned earlier.
But also, obviously, for-profit and unaccredited institutions could teach using, a clip using fair use if it weren't for 1201.
Thank you. Again, we appreciate everyone's, willingness to participate in the panel and this valuable, insight you've shared with us. I think we're going to wrap up only 25 minutes past the hour and then start again at 9 a.m. So thank you again very much.
Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.